Hi and welcome to munshigiri.com. In this tutorial, we're going to talk about the amendments in the Securities Contracts Regulation Act 1956. Now, the act through which amendments are brought in Securities Contracts Regulation Act is known as Securities Laws Amendment Act 2014. So now let's look at the various amendments brought by this act. The first amendment is in section 12A. This is section 12A. Now section 12A talks about the powers of SEBI to issue directions to any stock exchange or any person or company whose shares are listed or to be listed on a recognized stock exchange. Now the amendment in this section is that an explanation has been inserted in this section. Okay, the original section talks about the powers of SEBI to issue directions. Directions to whom? Directions to any stock exchange or any person, to any stock exchange or to any person or any company which company whose shares are listed or whose shares are to be listed Now the amendment is an explanation has been added in this section. Explanation that has been added is, it says that power to issue directions shall include. Now this power to issue directions, it shall include and always be deemed to have been included the power to direct any person who made profit or averted loss by indulging in any transaction or activity in contravention of this act to disgorge an amount equivalent to the wrongful gain made or loss averted by such contravention, which means that the SEBI has the power. Now this power to issue directions, it includes, and it has always been deemed that it includes the power that any person who has made any loss or who has made any profit by indulging in any transaction or any activity that is in contravention to this act, that is in contravention to the provisions of Securities Contracts Regulation Act, to disgorge an amount. Disgorge means to let go. Okay, to let go any amount equivalent to the wrongful gain made by such person or the loss made by such person. Let's quickly write it down. It says, now this power to issue directions includes and always deemed to have been included the power to direct any person which person, the person who made profit or averted loss by indulging in any transaction or activity in contravention of this act to what? To disgorge an amount equivalent to the wrongful gain made or loss averted by such contravention. Now this was the first amendment. Other amendments that we have is in the penalties. There are a lot of amendments in penalties actually. So let's cover them up. Amendment in sickness, amendment in penalties. So what we are going to cover here is that the section which has an amendment, the earlier provision and the provision after the amendment. So let me draw up 3 lines quickly. The first one is for the section, the second is for the earlier provision, and this is for after amendment. The first section is section 23A. Section 23A talks about failure to furnish information, etc., or failure to maintain books of accounts or records. It covers 2 things. First being failure to furnish information, etc., furnish information, etc., and the second point is failure to maintain books of accounts or records. Failure to maintain books of accounts or records. Earlier the amount of penalty was 1 lakh rupees for each day during which the failure continues. For each day during which failure continues or rupees 1 crore, whichever is less. Now after the amendment, the minimum penalty is rupees 1 lakh, and it says it may extend to rupees 1 lakh for each day, 1 lakh, and may extend to rupees 1 lakh for each day during which the default continues, or no, maximum is rupees 1 crore. So now you see there is no minimum penalty under the earlier provision. After the amendment, a minimum of rupees 1 lakh will be imposed in case of penalty. Coming to the next section that we have is section 23B. This is page number 2. Okay. And first for the provision, second for the earlier provision, and third is after the amendment. Section, earlier, and this is after amendment. Second section is section 23B. This section talks about the failure to enter into agreement with the clients. This is failure to enter into agreement with clients. Earlier the penalty was same as section 23A, and this is also same as section 23A. This is section 23A that we just covered. Earlier this, and after amendment this. This is same in case of 23B. Coming to next penalty, section 23C. Section 23C. This is penalty for failure to redress investor grievances. Failure to redress investors' grievances. Again, this is same as section 23A, and also this is same as section 23A. Coming to next that we have is section 23D. 23D is on failure to segregate securities or monies of client, or using securities or monies of client for self or for other client. This is 23 days failure to segregate securities or monies of client or using securities or monies of client for self or for other client. In this case, earlier the penalty was he was liable to a penalty not exceeding rupees 1 crore. Not exceeding rupees 1 crore. Now the penalty is which shall not be less than rupees 1 lakh but which may extend to rupees 1 crore. Now minimum penalty is rupees 1 lakh and maximum penalty is rupees 1 crore. Coming to section 23E. Section 23E. Section 23E talks about the penalty in respect of failure to comply with listing conditions or delisting conditions or grounds. This is failure to comply with listing conditions or delisting conditions or grounds. In this case, earlier the penalty was penalty not exceeding rupees 25 crores. And now after the amendment, the penalty is minimum rupees 5 lakhs and maximum same rupees 25 crores. Next is section 23F. Section 23F. 23F is penalty in respect of excess dematerialization or delivery of unlisted securities. Now this is excess dematerialization or delivery of unlisted securities. This is same as 23E, that is not exceeding 25 crores, and this is also same as 23E after the amendment, that is minimum penalty of rupees 5 lakh and maximum penalty of rupees 25 crores. Next is 23G. 23G is in respect of failure to furnish periodical returns, etc. Section 23G is failure to furnish periodical returns, etc. Again, the penalty is same as 23E, and in this case also this is same as section 23E. Now we have one more penalty left here in this section, is section 23H. Third page, and this is Section 23H. This penalty is in respect of any contravention for which no separate penalty has been provided elsewhere. That is, any contravention for which no separate penalty has been provided elsewhere. This is penalty. Earlier it was penalty which may extend to rupees 1 crore. And now the penalty is minimum rupees 1 lakh and maximum of rupees 1 crore. Now these were the penalties from section 23A to 23H. Coming to the next penalty is section 23I. This is in section 23I. 23I. Now the section 23I talks about the power of SEBI to appoint any of its officers to be adjudicating officer. Now the amendment in this section is that a new subsection has been inserted in this section. Now this section is power of SEBI to appoint any of its officers to be adjudicating officer. Now a new subsection has been inserted in this section which says the board, that is SEBI, may call for or examine the records of any proceedings under this section, and if it considers that the order passed by adjudicating officer is erroneous to the extent it is not in interest of securities market, it may, after making the inquiry, pass an order enhancing the quantum of penalty. Okay, so the new subsection that has been inserted, it says that SEBI, after the inquiry, has the power to enhance the quantum of penalty that has been decided by the adjudicating officer. Let's just write it down quickly. The amendment is a new subsection has been added. A new subsection has been added which says the board means Securities Exchange Board of India, may call for and examine what? The records of any proceedings under this section and if it considers that the order passed by adjudicating officer is erroneous to the extent that it is not in interest of securities market, it may, after making inquiry, pass an order enhancing the quantum of penalty. Pass an order enhancing the quantum of penalty. Now the penalty can be enhanced only after giving an opportunity of being heard to the person concerned. Enhancing the quantum of penalty only after giving an opportunity of being heard. To the person concerned. The subsection further states that nothing contained in this subsection shall be applicable after an expiry of a period of 3 months from the date of order passed by adjudicating officer or disposal of appeal under section 23L, whichever is earlier. It says nothing contained in this subsection shall be applicable after an expiry of a period of 3 months from date of order passed by adjudicating officer or disposal of appeal under section 23L, whichever is earlier. It means that the SEBI has the power to enhance the quantum of penalty only within 3 months from the date of order passed by adjudicating officer, or if the appeal is disposed of within 3 months, then this is lesser of these two periods. Coming to next section, that is section 23JA. This section has been newly inserted, 4th page, and the section is section 23JA. This is a newly inserted section. It talks about the settlement of administrative and civil proceedings. Settlement of administrative and civil proceedings. Now it says any person against whom any proceedings have been initiated or may be initiated under section 12A or 23I may file an application in writing to SEBI for settlement of proceedings initiated or to be initiated for the alleged defaults. That is, a settlement can be done. Any person against whom any proceedings have been initiated or may be initiated under section 12A or 23I may file an application in writing to SEBI for settlement of proceedings. initiated or to be initiated. For alleged defaults. Now the nature, gravity and the impact of defaults is to be seen for the purpose of settlement. The nature, gravity and impact of defaults. To be seen for the purpose of settlement. Now, appeal shall not lie under section 23L against order passed by board or adjudicating officer. Passed by board or adjudicating officer. Next we have is section 23JB. Section 23JB talks about the recovery of amounts. Section 23JB. This is about recovery of amounts. Now it says that any amount of penalty or any fees that is due from a person may be recovered from such person by one or more of the following modes. Now this section talks about basically the various modes through which a penalty or any fees that is due from a person can be recovered. Any amount of penalty or any fees due from a person may due from a person may be recovered from such person by one or more of the following modes. The first one being attachment and sale of the person's movable property. A is attachment and sale of person's movable property. Second is attachment and sale of person's immovable property. Third is attachment of person's bank account. Fourth is arrest of person and his detention in prison. Arrest of person and his detention in prison. And the fifth point is appointing receiver for management of persons' movable and immovable property. Appointing receiver for management of persons' movable and immovable property. This was about section 23JB. Now some new sections have been inserted under this act. They are section 26A, B, C, D and E. Let's look at these sections. I think this is 5th page. This is 5th page. Now, insertion of new sections in 26 series. So, it's insertion of new sections. And these sections are 26A, 26B, 26C, 26D and section 26E. First, let's take up section 26A. Section 26A talks about the establishment of special court. Establishment of special court. It says that the central government, for the purpose of speedy trial of offences by notification, establish or designate as many special courts as necessary. Now, special court shall consist of single judge who shall be appointed by central government with concurrence of Chief Justice of High Court. Central government, for the purpose of speedy trial of offences. Speedy trial of offences by notification, establish and designate as many special courts as necessary. Now, special court, it shall consist of a single judge, who shall be appointed by CG, with concurrence of Chief Justice of High Court. Chief Justice of High Court. Next is section 26B. Section 26B talks about the offences triable by special courts. Offences triable by special courts. All offences committed under this act shall be tried by the special court. All offences under this act shall be tried by special court. Third section is section 26C. This section talks about the appeal and the revision. Another is section 26D. Section 26D talks about application of code of proceedings before the special court. Application of code of proceedings it says that the provisions of Code of Criminal Procedure 1973 shall apply to proceedings before a special court, and for this purpose special court shall be deemed to be court of session, and person conducting prosecution shall be a public prosecutor. Prosecutor should have been in practice as an advocate for not less than 7 years. The provisions in respect of this are as follows. The provisions of Code of Criminal Procedure (1973) shall apply to proceedings before a special court And for this purpose, special court shall be deemed to be court of session, and person conducting prosecution shall be public prosecutor. Now the prosecutor shall have been in practice as an advocate for not less than 7 years. Next is section 26E. This is page number 6. Section 26E. So it says, until the special court is established, any offence committed under this act shall be taken cognizance of and tried by court of session exercising jurisdiction over the area. This is simple to understand. Now it says, until special court is established, any offence committed under this act shall be taken cognizance of and tried by court of session exercising jurisdiction over the area. That is, till the special court is established, as we saw under section 26A about the establishment of special courts. Until the special court is established, any offence that is being committed under this act shall be taken cognizance of and tried by the court of session exercising the jurisdiction over the area. Coming to section 32, this section is also newly inserted. It talks about the validation of certain acts. And now this is the last amendment in this act. This is section 30. This is validation of certain acts. Now it says, any act or thing done or purporting to have been done under the principal act in respect of settlement of administrative and civil proceedings that we just seen shall for all purposes be deemed to be valid and effective as if the amendments made to the principal acts had been in force at all material times. It says, any act or thing done or purporting to have been done under the principal act in respect of settlement of administrative and civil proceedings and civil proceedings shall for all purposes be deemed to be valid and effective as if the amendments made to the principal act had been in force at all times, at all material times. So this was all about the amendments in the Securities Contracts Regulation Act. So hope you enjoyed learning it. Thank you. Have a nice time.